I feel quite honored to be talking about something that I think is really one of the most sort of relevant topics, certainly, right now, and for being able to share sort of and discuss information around surveillance and security practices in Canada, and I think in the context of the Pan Am Games in Toronto too, it's a really important conversation. So just to say that, and I think talking about the Pan Am Games, of which this exhibition is sort of an official part, is important to remember that all of the ways that this changes our experiences of the city. So whether or not you are affected kind of directly by it, depending on where you live and maybe what your commuting habits are, you might have a sort of more or a greater or lesser relationship with the games, but whether it's a distraction or inconvenience or something that you're sort of excited about, the spectacle aspect of it, it also means very heightened security throughout the city and really increased spending on security in the city, which of course means heightened surveillance and different sort of powers that are afforded to policing and things. So in that context and where we are, I think that this is something really important for us to consider and to remember. And I know that Graham and then later Barbara will speak a little bit more specifically to C-51 and the Anti-Terrorist Act in Canada. But of course that's also kind of a very timely context for our conversation tonight, and with the recent news about the Charter Challenge and some of the ways that we might think about resisting or sort of trying to be aware in our resistance to what that legislation means. Is another way that this is kind of a very relevant and contemporary topic. So I really applaud Sir Gallery and Tamara and Legat for doing an exhibition like this at this time. I think it's I think it's just very important. I wanted to open by saying that. So for my portion of the talk tonight, I'm mostly going to actually just address some of the works in the exhibition because we're in it, and I'll do a little background on my interest in my interest in surveillance and art practices, and then hopefully we can have a bit more of a conversation around how that connects to some of the legislation that I know Graham is going to discuss. So I guess that's the question to start with, is sort of what does art contribute to the conversations around surveillance and around the surveillance state? What can art do, and are there ways that artists can give us different tools to think about knowledge production in this context, and maybe potentially different forms of resistance that might not be available through direct action or protest or in academia. So sort of what can a visual practice add to that? And so to give you a little bit of background, my interest in surveillance kind of came through work that I was doing as a master's student in contemporary art and photography, and thinking about the ways that photography is kind of a surveillance practice in and of itself, and the idea of the photographer as always kind of being about covert looking and ways of seeing and ways of knowing that are kind of about a power relationship between the photographer and the photographed subject. So I guess my interest in surveillance kind of came through imaging and imaging technology. And then I was working on a project on two American photographers, work by Terrence Simon and work by Trevor Paglen, who both use photography as a way to reveal aspects of state power and state secrecy in the American context specifically. So Terrence Simon has a project on the border called Contraband, where she photographs objects that are, she lived at JFK Airport for about a week, and she photographed all of the objects that were being contrabanded, that were taken away from people as they passed through customs. So she created this huge photographic project out of, this was over 1,000 images, of all of the things that are sort of threatening to the state. And most of them ended up being counterfeit. Like the vast majority were things that were threatening to American capital. And then of course the expected sort of drugs and guns and the other sort of expected things. But so that was one way that I began thinking about representations of surveillance, and the second was through work by Trevor Paglen, who is also an American artist and photographer, and who is quite, in his work, quite critical of the American state and the sort of NSA and the sort of spying and surveillance systems there. And one of his earliest projects called The Other Night Sky, in which he photographs the sky to collect images of covert communication satellites, so satellites that are not sort of officially there or sort of tracked officially by the government in any way, but that are used for covert communications. So in both of these, I think, just to sort of kind of state this interest around visibility, I think in both of these projects there's a tension between what's revealed, what the artist wants us to see, and what's hidden and sort of kept purposely hidden by the state. So I mean, in the instances of the border, those spaces are so heavily surveyed and secured and so inaccessible that we will never get to see them. So what artists might do is be able to reveal something of those spaces. And that tension between visibility and invisibility is not only one that's present for artists, although of course that's part of, I think, many or even most artistic practices is being able to articulate or name or make visible something that isn't otherwise. But that discourse around visibility and invisibility, or sort of transparency and opacity, is also, to me, kind of one of the key discourses in thinking about surveillance. Because there's a kind of tension on both sides. So to make something visible, to make it transparent, is not necessarily to give it power. What do I mean by that? So something that I think I'm challenged by in thinking through what visibility and transparency mean in these contexts is that it's a discourse taken up by two sides. So on the one hand, governments will use this as a rationale for increasing powers. So the need to kind of bring to light the sort of deepest, darkest threats, terrorist threats that are kind of lurking within our borders. This rhetoric around terrorism and bringing it to light is frequently used by the state. And then at the same time, that discourse to transparency is used by people who would disclose information. So Chelsea Manning, sorry. And WikiLeaks and Edward Snowden and the NSA being the most familiar right now, that need for transparency is also part of how we might resist modes of surveillance. So I think in thinking about art, there's something challenging in how we deal with visibility and what it means to make something visible and make something present in the gallery space through the circulation of images and all of the ways that we kind of come to know and see art. So I think kind of saying that sort of lays out maybe what my interests are in thinking about work of this kind, and then thinking about the exhibition that we're in and the ways that some of these artists kind of are dealing with this same issue. I think one of the first works that really struck me when I came in, or the first two, I guess, were these two, so Regina Silvera's and Marcos Ramirez Era's. In particular, I think the eye charts were really compelling because not only because of the text, but because of the way it kind of is referencing another type of unknowable or unphotographable space. Like the space of the doctor's office is this other kind of space that is institutionally regulating our bodies and the ways that we kind of exist in the world in some way. And so here you have mimicking the eye chart. So wherever you are in the gallery, you'll have a different ability to read it, and of course, depending on your physical capabilities and your eyesight as well. And so I think the artist is kind of forcing us to be positioned in a certain way in order to read these, in some ways, kinds of, well, really, in some ways, kind of direct texts. And the two on the right, the middle and the right here are the ones that I wanted to talk about. So the Salman Rushdie quote, even the freest of free societies are unfree at the edge. And then the Anais Nin, which is, we don't see things as they are, we see them as we are. And so to me, these two works kind of, in some way, sort of bookend a lot of the issues that are coming up in this exhibition. So the idea of the space of the border, and the idea that vision and kind of what we are able to see is contingent and dependent on a whole host of things. So for the Rushdie, I don't know if he's sort of speaking tongue-in-cheek maybe about American society and the, oh, thank you, and the ideology of freedom and the land of the free, but that even in those spaces, even in the freest sort of quote-unquote spaces, it's the border that remains unfree, and it's the border that is the space of contention, and the border that is, that we're so willing to sort of surrender those freedoms even in something that's so-called free. And of course the irony and the paradox there is that if it was a truly free society, we would have the ability to cross borders, like we would have the ability to move at will, and that's sort of what he, I think, is talking about in this like little snippet of text. So thinking about, you know, what the border does, not only just surveillance at the border, but how the border is kind of marking property, and its function is to maintain the power of people who already have power, of people who are already in power. And then the Anais Ninta say that we don't see things as they are, but we see them as we are. That, and this is maybe my, you know, one of my questions around the appeal to visibility and the appeal to transparency is that even when things are completely visible and seeable, vision is so contingent, and vision is something that is historically contingent. It's based on ideology, subjectivity, and all of the things that kind of make us individuals. So to me, there's a real tension there because, of course, revelations like WikiLeaks and like the Snowden revelations, that kind of transparency is absolutely critical. But at the same time, I think we need to be able to question the aspiration to transparency, and I think that that's probably one of the things that artworks can nuance a little bit for us in the conversation to make it perhaps a bit less polarized. I know I've got only a couple of minutes left, so maybe I'll just say a few brief things about the Regina Silvera work, because I think that this also has an interesting play between, of course, this interesting play between vision and this kind of lightness and the depth of shadow. So we have the single light bulb, and when the projection is on, there's like a little flickering light that is in the center, and then this like deep, like the sort of like depth of a black shadow emanating from the light. So instead of light being kind of something that's giving us knowledge or giving us the ability to see, in this instance, it's kind of taking it, retracting it or taking it away. And I think, of course, the clear sort of visual reference here is the interrogation room, the kind of single hanging light bulb. And so what can happen in those spaces that are likewise invisible and unphotographable and only exist because they can't be represented through imagery, but can instead be represented through, say, an artwork like this. So I think that there's, yeah, a tension there that's really important too. And then lastly, I also just wanted to mention, maybe we can have kind of further conversation, the Jota Castro piece, which I think and hope some of you have taken with you or have read already, which kind of provides this sort of social history of protest over the last 10 or 15 years as a takeaway. And when I first came and encountered that work, it kind of reminded me that there are ways of organizing and that there are ways of communicating that don't require, this is maybe just kind of a silly thing, but like that don't require like Twitter and Facebook and digital organizing, and that maybe a really important point of resistance is in the language and the circulation of language in print form, because maybe there are things that you can say in a gallery and distribute to, you know, a huge stack like that, distribute to people that you wouldn't say, that you would police yourself or prevent yourself from saying on Facebook, on Twitter, and on all of our kind of digital communications. And maybe that's one of the things that I'll just end with, is that thinking about the title of this talk, Art in the Age of Surveillance, and what that means. So like what the age of surveillance as a sort of demarcator of aesthetic practice means, and thinking about the ways that we can embody the social conditions of a surveillance state and respond in unique ways using some of the same tools. So how can we, and maybe that's an example, how can we use things that are going to allow us to resist being watched, being monitored, being tracked online, being imaged? How can we have the right to not be visible, the right to make ourselves out of the frame and out of view of the state, and how can we do that? And what is art's role in doing that? I think that those are all important questions that are being asked in the exhibition. So I'll maybe wrap it up there.
Thank you. Well, hello. I'm very pleased to be here. I was never a very good artist. I flunked most of my classes, and the charity of the teachers I might pass. So it's really a unique experience for me to be in this kind of environment. And I'd like to pick up actually on one of the points that you made about surveillance and security being timely, which it surely is. It's also timeless. I mean, in any political community, there's conflict, and there's this kind of sense of a threat to the life of that community. Canada is obviously no exception. In our history, surveillance has been used to target vulnerable minorities largely. One of the things that's timely, I think, about Bill C-51 and Bill C-44 is the use of technology. There's kind of two dimensions that I see to security these days, and one is the control of bodies, the control of movement of bodies, migration, which I'm sure Barb will talk about. And the other is the control of information and thought, and with that, language and identity. I'm going to try to speak a little bit more to that side of things. And I was actually, recently I had the, I'll use loosely speaking, the pleasure of being amongst some of the members of CSIS and RCMP the past few days in Vancouver at a conference where the government was trying to explain to an audience of somewhat skeptical audience what the objectives and the rationale for some of the new legislation are. And in addition to there being representatives from RCMP and CSIS, there were some lawyers in the room, especially those who helped draft the bill. And one of the things that really struck me was some of the things that they were saying in defense of the bill. The first thing that they said was that many of the powers that are in the new legislation were in fact already in existence, that CSIS already had many of these sorts of powers. The legislation is simply trying to clarify what those powers are, and in point of fact, it said, I can't name any names, I'm sorry, but one of the things that they're supposed to be doing is to add to the rule of law by clarifying what these powers are. So I'd like to challenge that a little bit, obviously. The second thing that they said is don't worry, most of these powers, especially those of internal surveillance, won't be applied to Canadian citizens. And right away, of course, why is it that only citizens are of interest to the government? And the third thing that they tried to say is that they vetted the bill very carefully for consistency with the Charter, and in their view, they have a really good chance of supporting the bill in court. And I'm sure that all three of those comments would not meet a fact check, but we'll see about that in a few years as the Charter Challenge goes forward. So what I want to kind of do is to explain, in my perspective, what's wrong with Bill C-51. And I think that kind of the one theme that we're looking at is that there's a transformation in the executive branch of the government. Aside, I could talk about how Parliament is abdicating its democratic responsibility to carefully review laws before enacting them. But I'd like to talk a little bit about how the executive branch has been given powers to preempt individuals before they cross the threshold from being risky, quote unquote, to being criminals. So what we're seeing is the beginning of nothing else than total information awareness and some degree of thought control and character control. So there's two ways in which this is happening, and one is on the police side of the equation. Normally in criminal law, policing is reactive. They get a phone call saying a crime has been committed or is being committed. Typically, police are not in the business of investigating people before they commit crimes. That's very different in two main areas. One would be organized crime, as I'm sure you can imagine, and the other would be counterterrorism and national security in general. So what this means is that before being investigated by police, you normally have to engage in a guilty act. Counterterrorism offenses tend to be very thin on actual action and very large on thought or expression or association. What websites do you visit? What keywords do you search? What sorts of individuals do you interact with, right? And all of these things are compiled through computer databases and various forms of programming, which I kind of phased out because I don't understand computers very well. But the RCMP was explaining that they have these algorithms that they have tripwires. And so any individual who visits particular sites one too many times or uses too many keywords one or too many times, there's a tripwire, and that information is sent to some local police force or local branch of the RCMP, and there's a threat assessment made from levels 1 to 4. Level 1 is basic threat, 4 is the most serious threat. So they told us, and sometimes they said things they probably shouldn't have said. They have about 1,500 to 2,000 individuals who are currently within this 1-to-4 threat ratio. Most of those individuals have not actually done anything criminal, but they're being investigated for criminal activity. So when you look at Bill C-51, one of the ways in which this existing power is being validated or rationalized and amplified is through this advocacy and promotion of terrorism offense. So the offense states that anyone who knowingly, through any statement, advocates or promotes terrorism is guilty of an offense if they do so knowing or being reckless with regard to the fact that an offense, a terrorism offense in general, may be committed. So basically, if you say something that can be construed as advocating or supporting or promoting terrorism, and it's possible, just possible, there's some 1% chance, that's the standard for reckless, if there's a possible chance that somebody might act on that, then you are caught within the investigatory purview of the RCMP. And in fact, you may be liable to imprisonment if there's a conviction. And so this empowers certain police forces to start to obviously pay attention not to what you're doing, but to what you're saying. This would include, and there are a couple academics in the room as well as journalists in the room, this includes individuals who through art or through journalism or through academics write something that can be construed as sympathetic to what is a listed entity. So if you say something in support of the LTTE, for example, that can be, under the right circumstances, construed as a criminal offense. If, as a journalist, you write and you quote certain individuals, that possibly can be construed as a criminal offense. I think Barb will talk a little bit about how courts might interpret this provision and whether that would withstand charter scrutiny, but it's interesting just to note that these are some of the powers that are being handed over. Right, on the other side of the equation, you have CSIS. So CSIS is a security intelligence agency which traditionally was mandated simply to collect and analyze information. It was not authorized to approach individuals except for the purpose of collecting that information. Certainly wasn't authorized to engage in any kinetic powers such as arrest or detention or other forms of disruptive activity. So what CSIS would normally do is collect all of this information and keep it to itself. One of the things that makes CSIS somewhat effective from the government's perspective, but scary from the perspective of pretty much everyone else, is a very low threshold to get warrants to engage in intrusive surveillance such as wiretaps or going through your email. They need to demonstrate simply reasonable suspicion that you pose a threat to the security of Canada. Traditionally, a threat to the security of Canada would be your classic threat: espionage, foreign influence, terrorism, trading in nuclear weapons or materials, these sorts of things. One of the qualities of Bill C-51 is now that information which is collected by CSIS may be shared with institutions other than the RCMP and may be taken from institutions other than the RCMP if you pose a threat to the security of Canada, which has a second, more expansive definition. This would include generally posing a threat to the sovereignty or the territorial or economic integrity of the country. So one of the things that was mentioned in defense of this particular provision was that the threat needs to be of a national nature. I muttered to myself, that's a lie. I don't think anyone heard, but that's actually not true. The kinds of activities that can pose a threat to territorial integrity would at the very least include Aboriginal activism. Many Aboriginal bands don't recognize the sovereignty of Canada on the grounds that, in fact, sovereignty was never legally under international law asserted. The land was taken. And you also have Quebecois separatists would fall within this category. Some environmentalists who oppose economic pipelines, oil pipelines, might very well fall within this category. What's really interesting, I find, also about this provision are a couple of things. Firstly, traditionally, CSIS had to collect its intelligence on its own, right? It would have to go through open sources, through the internet. It would have to have a covert operative. It would have to have an informant, a human source, or it would have to get information from foreign sources like the CIA. These days and now, the CSIS can extract information from FinTrack, Financial Department, Department of Finance of Canada, from Health, any department, well, 17 departments, so almost all departments within the federal government of Canada may send your personal information to CSIS. And the condition here is that the information may be collected if not only you pose a threat to the security of the country, but you are engaged in unlawful behavior. parking illegally, by definition, is unlawful behavior, right? Protesting without a permit under certain circumstances is unlawful behavior. Once that threshold is met, that information can be collected and stored. So one of the difficulties, obviously here, is how do we constrain these sorts of activities? Again, the justification for these powers on the part of CSIS, I remember very clearly. We had a CSIS guy who looked every bit like you'd expect a CSIS person to look. He's got his nice black suit and sunglasses. Basically, we've been irritated. These past 14 years since 9/11, we've been irritated because we can't get access to information from Canada Revenue or Tax, for the Department of the Environment, from the Treasury. Can't get information from the government because it's protected under very rigorous privacy laws. And many of those departments have rigorous oversight and review with respect to the handling of information. So what this is doing is it's removing the safeguards, including in particular oversight and accountability, so that not only are these institutions being given access to this information, it's being given access without there being adequate oversight or review, so that we can be sure that the information is being collected properly under the reasons that were identified in the legislation, that they're being stored properly, not being sent to, let's say, the CIA or any other external agency. And of course, anyone who's being surveilled by CSIS they're not legally entitled to be informed of that. If the police have a warrant on you, now, for example, within 3 years, you'll receive a letter in the mail saying that there was a wiretap warrant issued against you. The police have to notify you at one point within a 3-year period after the warrant was issued that they've been watching you. CSIS, if they don't continue it, right. CSIS does not have to do that. Right? And so this is one of the issues with privacy, is that in terms of what you were mentioning about information is being collected, but you don't necessarily know that. So the third thing that's I'm going to speak about in Bill C-51 would be the granting of what's called kinetic powers to CSIS. Like I was saying before, CSIS is normally, historically mandated only to collect and analyze information for the purposes of identifying security threats. With kinetic powers, they're now given the ability to interrupt or disrupt terrorist activities, which means that they can now engage in operations both domestically and abroad, which would involve police-like powers. So one of the elements of the Bill C-51, which I think would be interesting to talk about, is that if CSIS gets a warrant from a federal court judge, it may violate charter rights and freedoms, with the exception of 3 forms of activity. They're prohibited from violating the sexual integrity of a target, they're prohibited from obstructing justice, and they're prohibited, I forget what the third one is, probably have to take a look at my notes, serious bodily harm and death. So one of the issues that's being seen through the courts right now is whether that particular provision is inconsistent with the Charter, on the grounds that the Charter is not intended to provide powers, it's intended to constrain powers. Charter is there as a way of is a disincentive for law enforcement officials or security intelligence officials to violate the law to begin with. But if that happens, there are remedies that are offered in many cases. What this particular provision does is it kind of bypasses that normal process and says ahead of time that a judge can authorize a breach of a charter right. And one other feature which is somewhat interesting is that if CSIS is operating abroad, they may violate foreign law. There makes some degree of sense. You don't have to comply with the law of the state you're spying on, but that would include as well the human rights or the constitutional rights of those foreign jurisdictions, and arguably would include international human rights obligations. So I'll just stop there, and I'll kind of end by saying that it was very instructive, the kind of experience that I had. I have a kind of a mixed feeling on these sorts of things. When the government sends representatives, those representatives speak somewhat candidly and sometimes say things that they shouldn't be saying. And you get a sense of where they're coming from. And my sense was, CSIS I'll leave out, I think they're pretty happy with the powers that they have. But my sense is that from the RCMP, they're not entirely happy about some of these powers. In particular, they're not happy about the advocacy and the promotion of terrorism offense. From their perspective, that's very, very difficult form of police work that police just don't have a history with. Like I said before, law enforcement officers tend to be reactive, and that's where their training is. They're trying to get used to using laws that require them to identify risks before they materialize into criminality, and they're not used to that. And my sense is that they're not sure that this is going to be a very useful offense. Nonetheless, because they're police officers, they've said they're going to enforce them to the letter of the law. So anyway, I'll stop there and happy to entertain any questions about that.
Thank you. Hi, I'm in this panel speaking as an artist and focusing mostly on my practice, but before I talked about a couple of my works, I wanted to start with that photograph over there, which is a picture of a drone that was being flown by what seemed to be a sort of group of young creative entrepreneurs in the middle of one of the free concerts that was happening as part of Panamania. And it really struck me that while a good friend of mine and I were watching Ana Tijoux, who is a Chilean-born, France-based poet and hip-hop artist who's very outspoken and who's very political. And as she was singing a song about dreaming of a world beyond the police state and dreaming of a world beyond dictatorships, at the back of the concert, there we had, this drone flying over top, and then at the level that we were, which was on the little bridge where you can see the performances from, this group of young people sort of having a friendly chat with the police officers who had come to see what was happening, And one of the really surprising things for me was that far from being shut down, they really seem to have struck a kind of nice, friendly conversation. Eduardo's going to help me out with the PowerPoint, so I'll just say next. Like Sally mentioned, I am a visual artist, mostly working in performance. I was born in Guatemala, and I came to Canada as a refugee claimant in 2001. I came in April. Me and my family came in April, which was right before 9/11 and right before many of the legal provisions that have subsequently not just closed the border, but really sort of created a much sort of tighter surveillance state came into effect. So in many ways, I see a lot of what I do in my practice as a kind of bearing witness to many of the changes in the public sphere, that have tightened borders, that have expanded surveillance powers. And I think, while I think, thinking and talking about the legal and the technological implications of this is important, I think the thing that I'd like to bring back, and the thing that I try to bring back with my work is the physical, the emotional, and the mental effects that these changes bring onto us as bodies, as beings. The first piece that I'm going to talk about is a site-specific performance, which is usually performed in galleries. It's called Spatial Profiling, and it is it's a very simple gesture. It is the repeated tracing of the outline of my profile as I move very, very, very slowly through a space. So can we have the next one, please? And usually the performance takes place in relationship to an architecture. It takes place for as long as the wall lasts. And next. And then next. Sorry, I'll have to do quite a bit of that. One of the things, I performed this piece in a number of places. I performed it here in Canada as part of Mayworks, which is the Festival of Working People and the Arts. I performed it in a more perhaps abstract way in Finland and in the United States. And one of the things that I've started to do with this work is that I've started to vacate my body as a performer, and I've started to ask people to become the performers in it. This is a shot from a performance of it in Vancouver last summer for a drawing festival, the Drawn Festival in Vancouver. And I think one of the things that interests me in sort of repeating this gesture and taking on this gesture as a kind of long-term project is the idea of tying a little bit into what Jane was saying about the relationship between what is visible and what is invisible. Claiming a space for that which cannot be rendered as an object of knowing. That within us as sentient beings, as intellectual beings, that cannot necessarily be reduced to evidence, the complexities that cannot be reduced to evidence in the way that this kind of change in the public sphere tends to do, in the way that it tends to polarize. The next, and as you can see, there's a certain sort of strange, almost perversity in the sort of shifting of the gesture from my body onto other people's bodies, because then all of a sudden that body of the performer could be anybody, and yet the trace remains unrecognizable. The second piece I'm going to talk about is the result of a conversation that I had in a randomized webcam service, webcam chat service called Chat Roulette. If anybody remembers it, it was fairly it was like really hot for about 2 weeks in about 2010, and this was a sort of technological means to randomly chat with people all over the world, where you would connect with your webcam and you could chat back and forth. And this conversation is the result of a young man somewhere in the world, which I cannot necessarily know, his response to my appearance. So the first thing he says is, "Faggot, are you a terrorist?" And while usually I think that would have, rather than the reaction that I expected to have from that encounter, which was anger, the impulse to deny, the impulse to prove him wrong, or to engage, without me necessarily understanding, I began to actually refuse to either confirm or deny his sort of hailing of me as both a faggot and a terrorist. And I began to turn the questions back on him. "What do you think?" And so his response is, "You look like one. Maybe I am a faggot terrorist." And then he says, "Yeah, I reckon." And the moment when I switch the sort of request for identification and I ask him, "What would that make you?" Is the moment where he actually cuts the communication and moves on to the next thing. One of the things that I tend to work with a lot in my practice, because I use my body, because I tend to be in my work quite a bit, is the ambiguities of my body. My racial ambiguity. I'm Latin American of mixed heritage, but and many of you who know something about the context of Latin America know that European heritages are greatly celebrated and traced, whereas indigenous heritages are erased, to a point of making it impossible, certainly for somebody like me, to be able to name and pinpoint the parts of my body that I can tell, that I feel are something other than European. And so, as somebody who came to this country as a refugee, and as somebody who went from being a refugee claimant to being a citizen, coming into that space of subjectivity, becoming the subject of the citizen, I became really interested in the case of Omar Cotter. I became interested in him because he came to Canada I came to Canada a year after he went to Afghanistan. He was put in prison just as I entered college. He would all throughout the time that I was an art student. He was in Guantanamo, and then around the time that I was graduating from my master's was when he was, after being held without charges for a long time, when he was finally sentenced in Guantanamo. And so I was really interested in noticing the almost opposite trajectory of our paths. I noticed that as I was coming into this subjecthood of citizen, as I was becoming a citizen, he was going so far away from what we can even recognize as a legal subject, as a person under the law, that I really felt compelled to try to think about this impossible relationship, not as one of comparison, and not as one of me even knowing what it would be like, but one of an impossible correspondence. So I did a performance at the University of Toronto Art Centre called Apostrophe. An apostrophe, besides as a sign delineating a kind of absence within language, as a rhetorical device, marks the part in a sort of theatrical scene when a character turns away from the scene and towards the audience, or when a character addresses an abstraction and begins to speak. And so the piece is called Apostrophe because I realized that what I was really speaking to wasn't necessarily Omar Cotter himself, because he was beyond, at that point certainly, in 2012, he was beyond the reach of the address. So I decided to create 3 actions for him. During the day of the opening, I counted the days that he had been in prison from the 22nd of October of 2002, which is when he went into, which is when he was captured, to the 23rd of March of 2012, and that was 3,438 hatch marks. Throughout the rest of the exhibition, I read a book. I read Romeo and Juliet, which was one of the books that he had been reportedly reading during his jailhouse, during his prison education. And I blanked out, can we go to the next one? And so those are the hatch marks. And then if we go to the next one, I blanked out everywhere in the text where Romeo's name appeared and his dialogue, both as a way to sort of signal the kind of silencing, but also as a way to make space, where this character might at some point speak. And the third action was the writing of a letter, which at the time I did not send because he wasn't really reachable, and which now that he's free, I'm seriously considering sending, but not as part of the artwork, as really a personal gesture that would be beyond the artwork. One of the really important things to say about this work was that one of the first decisions that I made was that I would make a work about the case that did not use his image. It was really important for me because his image had become such an object of circulation, that the work address this impossible relationship without rendering him as an object. During the time of the performance, I in fact did not even use his name. It was only through a curatorial essay that was written by this Paglen that you would know what the performance was about. Now that he's free, I talk about it. And then very, very briefly, the last piece that I'll just mention is called Movement Study, Standard North American Strip Search Procedure. And in a way, as a kind of reaction to this impossible correspondence and really thinking about my position as a citizen, now a precarious position as a citizen, given the recent developments in citizenship law, but still, as a citizen, as a reaction to that, I think I really wanted to think about that precariousness of the position of the citizen, of the legal subject. And so all it is it takes the behavior, the movement of the body in standard strip search procedure by police and turns it into a ready-made to be performed in a gallery. One of the things that struck me and really sort of terrified me was the way in which the actions of a standard strip search procedure already looked and felt like a work of performance art. So each article of clothing needs to be taken off, turned inside out, shaken, and thrown beyond reach. And then there's a kind of indexing of the body. You run your fingers through your hair. You show the inside of your mouth. If you have breasts, you lift them up. If you have a foreskin, you have to pull it back. You turn around, you squat, you cough. And you know, and one thing that I've been realizing actually about, just as a way to wrap it up, about this piece is that when you think about what's becoming standard police procedure, and when you think about the fact that there are bodies who don't even have the privilege of being strip searched. There are bodies that are immediately assumed to contain some sort of danger within them and immediately shot. And you know, we're talking about racial profiling, we're talking about black bodies, we're talking about indigenous bodies. I've recently begun to actually think about this piece and the process of a strip search procedure as a kind of privilege, you know, as a kind of the thing that should come before, you know, being shot. And it's been disturbing to realize this, but I just thought about this today, and I shall leave you with that. Thank you.
Thank you. So I guess I'm the last. I'm a lawyer. I represent people who have security problems in Canada, and it's interesting when you're talking about the art, like in terms of what you see or don't see. I didn't see those things, by the way. I'm not an artist, but now that you say it, I see it. But you know, it made me try and think of what it is as a lawyer, how it shapes up in terms of the concerns that you raised. And I guess if I had to sort of visualize what I do, it's like walking through a fog on jello, because you don't know what you're dealing with. Information is secret, and you don't know where you stand. The standards of review that the court uses are so malleable that they can always find a reason to find a person to be described and to be a threat to the security of Canada. So it's interesting because it very much fits what's there in those pictures and what you're trying to show through your art. With respect to a couple of comments about your speeches, one in terms of the conversation that you had online, that maybe I am a terrorist or a faggot, that would draw the NSA to profile you. So I think you need to watch what you put online, because I do. I don't use the word terrorist in my emails if I can avoid it, because I know it's a buzzword. It will cause someone to look at what I'm sending to people. And it's that broad. It's not that they're specifically looking at me, it's just they've got this trolling thing where they're picking up things on buzzwords and trying to figure out who's who and what's going on. It is that broad, and you do need to worry about it. The national security establishment, I think, is problematic, and that's not even talking about the broad powers that CSIS has. The other thing was Omar Cotter. I feel so sorry for that kid, or young man, what he is now. He was going away from citizenship or becoming a non-person through the time when you were becoming a citizen. He stands to lose his citizenship under the new legislation because he has an 8.5-year sentence unless it's quashed. He comes within the class of persons who, even though they were born in Canada, may lose their citizenship if they have access to a second citizenship. So Omar's grandparents immigrated to Canada. His mother was born in Canada. He was born in Canada. He's second generation. His dad was born in Egypt. Through his father, he can probably get Egyptian citizenship. And as a result of that, because of the 8-year sentence in the U.S. on what can be called a terrorism-related offense, even though it wasn't an offense under the rules of war, my understanding of the rules of war, and the fact that it was a war that was going on at that moment, the U.S. was occupying another country against its will. But in spite of all that, if that conviction stands, then he comes within the class. They'll send him a little letter saying, guess what, we think you shouldn't be a citizen anymore. And he gets a review of that in federal court after the fact. And that's some of the problems that, what I want to talk about is not so much all the stuff that's in the act that Graham talked about, but sort of some of the key problems in terms of how you work your way through it. First is the scope of threat to the security of Canada. And I mean, I get paranoid about this because I've probably done too many cases where people are being called terrorists because they're not terrorists. And I'll give you a good example. In the Immigration and Refugee Act, members of a terrorist organization are barred from Canada. So you would think it would be people who joined the organization, but there's not enough people who joined organizations that are coming to Canada, so they have to broaden it. It has been interpreted to cover the wife of a member of parliament in Sri Lanka, who because the Tamil party he represented, spoke for the LTT, the Tamil Tigers, in the at the end of the war and in the 2004 elections. The LTT supported that party. Because of that, her husband, who was the MP, was assassinated. And because she was his wife and cooked him dinner and transcribed his notes and knew what she was transcribing, she, as his wife, was a terrorist. He wasn't even a terrorist. He was an assassinated member of parliament. But because his party and the LTT shared a common goal of self-determination, even though they chose different paths, one through violence and one not, it was enough to draw them together, and then to draw the wife in and make her a terrorist. So if you take that paradigm in terms of all, we have a country full of people who cannot get their permanent residence, cannot get their citizenship because of stupid rulings like that. And I can tell you what happened with her case. She didn't even get permission to argue the case in court that she wasn't a terrorist. So this is the court that will apply the new provisions, that will apply the new provisions in any event. So in any event, if you look at the new legislation, there is a very, very broad interpretation of activity that undermines the security of Canada, one of which is interference with critical infrastructure. If you protest in front of the courts, you protest and stop people from coming in, you protest in front of a post office. I mean, that's not as critical anymore, but it used to be. Anything like that, they can argue that that's interference with critical infrastructure. The judicial system is a critical infrastructure. It doesn't have to be violent for an act to be a threat to the security of Canada. And I'm sure they won't find enough violent acts, so start moving around and trying to find things that are nonviolent. The other thing that's in that definition is an activity that takes place in Canada and undermines the security of another state. The BDS campaign against Israel. That undermines Israeli security, arguably, and is an activity that takes place in Canada. This government is very pro-Israeli, very anti-Palestinian. I do a lot of cases like that. The Canadian Air Federation had their funding cut because their president in January of 2009, when Gaza was being bombed and so many civilians were being killed, that's before the more recent one, spoke out against the Israeli government, and the funding for language training got cut to the Canadian Air Federation. There was no violence involved. It was speech, pure speech. That case is in the Federal Court of Appeal right now. So with these kinds of broad terms, the activity that can be caught is very, very broad. That's the first starting point. The second starting point is once they've got you profiled, or that you've done something like that, they can build a case against people on nothing. The kinds of cases that we see are of the Canadians that have been subject to security problems, or the non-Canadians that are subject to the security certificates, is that it's based on association and contact. So in Hassan Omri's case, this case is public, they used the websites he went to selectively. So they didn't show the websites that he went to showing that he was trolling for news in general. They just picked the ones that were critical. And those are the only ones. Later on, his counsel got access to the computer and was able to show that he wasn't just trolling for negative websites, he was trolling for news, for all websites. He had BBC, he had CBC, he had everybody. I mean, I don't remember the websites, but it's a selective use of where you're going on your internet. And that's important because that is part of how they build it. The other thing is association with people. You go like Abdullah al-Malki, Canadian citizen, ended up in Syria like Mr. Arar and Mr. al-Mahdi. Abdullah Maher Arar had coffee with Abdullah al-Malki, and Maher Arar ended up in jail because he had coffee with Abdullah al-Malki, ended up in jail in Syria. That was the association. They didn't even know the content of the conversation. The two men had coffee one day, and that was enough. So those kinds of, it's association, the websites you use, the content isn't necessary to build a case against the person. They don't need to know what Abdullah and Maher Arar were talking about. They just know they had coffee together, and that was enough to say Maher Arar was a terrorist. The other problem with it, with the law, in terms of its broad use, is how it gets dealt with, both in terms of taking legal action and then reviewing that action. So if CSIS takes steps against the person, issues a security certificate, or deems him to be a threat to the security of Canada, the test they're using is reasonable grounds. Do they have reasonable grounds to believe? That is not more likely than not. It is a possibility. And a possible chance you're not doing something wrong. But a 10% chance you may be is enough. And it doesn't have to be on evidence, it can be on information. And there's a big distinction between that, because information may be gossip and innuendo, and one of the things this new legislation does, which CSIS did not have before, is protect its informants. So CSIS can now get information from people, gossip, build it up. They may say, I mean, we could never get at this in any of the cases, but say you canvass the community and two people say, oh, I think he's a terrorist. In fact, I've seen that in a case out in BC where the allegation from an irate brother-in-law was, I heard through friends that he had been involved with one of the terrorist organizations. Whereas the rest of the people they talked to said, no, nothing like that they'd ever heard of. So they used the one against its selective. But you can't get at it, and that's enough even if there is 1 out of 20 to meet the reasonable grounds test, to believe, because you've got 1 out of 20. So, and they, as I said, they don't have to provide actual evidence of the person being a member, it can just be gossip. The other point about that is, does that mean I have 10 minutes left, or I use my 10 minutes? Oh, I'm sorry. It really goes fast. Yeah. I'll be really quick. The second point about dealing with these issues in court is that the court, it's a double reasonable. CSIS has to have reasonable grounds, so possible that they can do this, that the person's doing something wrong or may do something wrong. And then when it gets to court for review, the court has to determine if that's reasonable. So the court is using, it's a double possibility test. So you have no chance whatsoever unless you have a good judge who's really prepared to take issue with some of that evidence. But the easier course is just to say, all right, on this low test, you know, anybody can be a terrorist, and anybody, in fact, is a terrorist. Then the second point, if they want to target you, they can target you. The next point is just the disclosure. That's why I say walking in a fog. We didn't know the guts of the case against any of the security certificate detainees. Not at all. It was secret. We never saw it. I know from past slip-ups that the kind of evidence they keep secret is not justifiably something that they should keep secret. So we get something in the course of an access request 3 years before, and all of a sudden we get a document where that's blacked out. So we tell the court, wait a minute, we already got this. We know what's blacked out. They still won't. They won't take the blacked out part away, and they ask for the document we have back. So that's how that works. So disclosure is really a problem in terms of trying to prove the case against you. And then just the last point is, CSIS and the RCMP have had ongoing problems between themselves, and that goes back as long as I've been practicing as a lawyer, and that's like 30, 35 years. Since CSIS has been around, since '84, there has been a friction. This bill creates an incredible friction. The and this was in the paper the other day, the RCMP is busy trying to do an investigation to lay criminal charges. CSIS has the power to disrupt. And in disrupting what they're doing in order to protect the security of Canada, CSIS thinks, they disrupt the investigation, no charges ever get laid, because they don't let the RCMP finish what they're doing. So there's going to be more tension between the two agencies. That doesn't benefit anybody. So there's other things I could say, but I'll leave it.